Hi guys, welcome back to our YouTube channel. Today I will be discussing domestic violence in South Africa with you guys. So if you are someone who's suffering or going through domestic violence, or you know someone, then this video will be very useful and informative to you. So what is domestic violence? Because most people do not know what domestic violence actually is. It is a pattern of abusive behavior in any relationship that is used by one person to gain or maintain control over another person. It is regarded as a serious social evil, and South Africa is one of the countries with the highest increases of domestic violence. The Domestic Violence Act of 1998 was enacted with the main purpose to afford the victims of domestic violence maximum protection from domestic abuse that the law can provide. The Act further introduced measures which seeks to ensure that the relevant organ of state is committed to the elimination of domestic violence. The statistics that the World Health Organization found is that 60,000 women and children are victims of domestic violence on a regular. South Africa is said to have the highest statistics of gender-based violence on the 22nd of April 2020 by the Minister of Police himself, Mr. Becky Cele. There are many types of different abuses that amounts to domestic violence. It could be physical abuse, it could be sexual abuse, it could be emotional, economic, psychological abuse. Most people did not know that economic abuse can also amount to domestic violence, or even emotional abuse. Someone could just be swearing you or threatening you on a regular. It's abuse, guys. They can threaten you or harass you or cause damage to your property or to yourself, or they could even just be stalking you. This does amount to domestic violence. So, the required documents when you do go and open up an interdict, you will need a certified copy of yourself and the other person. If you do have the ID documents, it's not always difficult to get. However, you also just need their details like their name, their surname. ID number is very difficult to find, but where they live is very important. These are the things that you will need when you go and apply for a interdict. The procedure that you would need to follow is that you would then need to approach the district court domestic violence department. It's usually in the magistrate's court. And then you would need to, on affidavit, state the nature, extent, and the severity of the incident that the other person has caused to you, with all the relevant details such as the exact dates, the exact spoken words if it's emotional abuse, and the violent conduct that the other person has documented. Domestic violence interdicts may only be brought by family members and not like your friends. Like, it could be brought by your mother or your father or your brother or your sister or your spouse. The magistrates will then grant an order against the other person intending to prevent further violence to you, failing which the criminal prosecution will be taken, the criminal prosecution route. The other person or the respondents will then have an opportunity to come to court to respond to these allegations before a final order is granted. However, it can be granted in this person's absence if they intend of not coming to court or they purposefully not come to court. Where can the applicant, or where can you apply for a protection order? You can apply for a protection order at the domestic violence section of your nearest magistrate's court, or the magistrate's court that is closest to where the person who is abusing you lives or works. What does the Constitution of South Africa say about domestic violence? In terms of Section 12, subsection 1 of the Constitution of the Republic of South Africa, everyone has the rights to freedom and security, which includes the rights to be free from all forms of violence from either the public or private persons. In another case that is on the website, and the cases details is on the website. The constitutional court, in this case it's called S versus Beloy, if I'm pronouncing it correctly. So the citation of the court case is on the website. The Constitutional Court pointed out in this case that the specific inclusion of private sources emphasizes that serious threats to personal security arises from these sources. So the presiding judge on this case indicated that when you read the constitutional section 12 subsection 1 of the Constitution with section 7 subsection 2 of the Constitution, section 12 subsection 1 then obliges the state to protect everyone's right to be free from violence, including domestic violence. So the constitutional right is bodily and physical, psychological integrity, the rights to dignity, the right not to be tortured in any way. Let me repeat this. The constitutional right is then bodily and psychological integrity, the rights to dignity, and the rights not to be tortured any way should be protected at all times. The right also not to be treated or punished in a cruel, inhumane, or degrading way also obliges the states to deal with domestic violence more seriously. The application process of the entire of you going to court, like I said, you can apply to the magistrate's court, where the clerk of the court will then help you, and the clerk of the court will then submit this application form to the magistrate. So against who can you seek a protection order? Because protection orders are very common in domestic violence. A person whom you are married, whether by civil or customary rights, your partner lives or has lived together with you, even though you are not married to each other or are not able to marry each other. The other parent of your child, person who shares parental responsibility with you by blood ties, marriage, or adoption, a person with whom you shared engagement, customary or dating relationship, including an actual or perceived romantic, intimate, or sexual relationship of any duration, a person with whom you share or have recently shared the same residence. Basically, any person that is close to you that causes harm to you, whether emotional, psychological, or physical, you can get a protection order against them. The court proceedings, what happens in court when there is a domestic violence case open? Proceedings under the Domestic Violence Act are conducted in camera, which means behind closed doors. The only person who may be present in court at this time are the parties, their legal representative, someone who brings an application on the complainant's behalf, witnesses, officers of the court, and not more than 3 persons to provide support to the complainant or to you, who is the complainant, and the respondent or the other person. The court may exclude anyone from attending parts of the proceedings and may exercise any other power to hear the proceedings behind closed doors. The Act prohibits the publication of any information which may directly or indirectly reveal the identity of any party to the proceedings. It is in the interest of justice that the court may further direct that any other information relating to the proceedings may not be published. Such a direction does not apply to the publication of a bona fide law report which does not mention the names or reveals the identities of the parties or witness. When I say bona fide or bona fide, it's just a Latin term. If I'm pronouncing it correctly, everyone has a different way of pronouncing these Latin terms. It just means good faith. So a good faith, a report that was written in good faith, basically. So contravention of the prohibition on publication is a crime which is punishable with a fine or a period of imprisonment not exceeding 2 years, or both a fine and imprisonment can be imposed. How much does it cost to go to court with domestic violence? So, any party or legal representation and cost, any party to the Proceedings under the Act may have legal representation present. If you are underrepresented, the clerk of the court must inform you of the relief available in terms of the Act and the right to lodge a criminal complaint against the other person if a crime has been committed. Each party bears his or her own cost unless you have acted frivolously or fraudulently or unreasonably, then the courts can order a cost order against you or wasted costs. Protection orders. You have two types of protection orders. You have a interim protection order, which is not permanent, and then you have a final protection order. So interim protection order is the courts may not make an immediate protection order. An interim protection order is made if the court is satisfied that there is prima facie evidence. Prima facie or prima facie means at first glance, the court is satisfied of the evidence before it. The courts must also issue a warrant of arrest when issuing the interim order. A court date is then also set for both the applicants and the respondent to appear on this court date. Then a final protection order is then granted thereafter, after proper service by the sheriff on the other party of the interim protection order. After this has been done, the respondent or the other party fails to appear on the date specified, the court must then confirm the order in his absence or in absentia. If the respondent does appear and opposes, the court must hear the matter as a proper court case. If the court then finds on a balance of probabilities, which balance of probabilities means whichever is favorable of the evidence that is more favorable to the one side or to the other side. So if the court does find on a balance of probabilities that the other party has committed or is committing an act of domestic violence, it must issue a final protection order. If a protection order has been granted and there's a breach of this protection order, the person will then be imprisoned. How to set aside a protection order in this instance? A protection order can be varied or set aside upon good cause being shown by the other party. However, if you make an application for variation or rescission means you want to you want the protection order to be reversed, or you don't want it to be in place anymore, something like that. If you make this as the complainant, if you make such an order, the court must then be satisfied that the application is being made freely and voluntary and that you are not being forced or solicited into doing this or into applying for such an application. Furthermore, as an upper guardian of all minors, the High Court may also set aside a protection order if it is in the best interest of the child, if you have a child with this person. So that is domestic violence in South Africa. That is how the law governs it. This is not completely... It is not close-minded in court. It is also based on the merits before the court, based on the evidence before the court. The court does look at every case separately from one another, so there is no set outcome for everyone. Nobody gets the same outcome because the court does look at the evidence before it. But if you do know someone, or if you are someone, please do not be afraid. Go to court and just see what happens. If you enjoyed this video, please like and subscribe to our YouTube channel. Give it a thumbs up and then stay tuned for the next video. Thank you so much for tuning in. I hope you guys really enjoyed this one. Good.